Welcome back to The Rose Report, a podcast where lawyers break down legal issues embedded in current events. I'm Madelaine Braggs.
I'm Olen Lenets.
And I'm Dan Gauthier. This podcast is provided for entertainment and informational purposes only, is not intended as legal advice, and does not form an attorney-client relationship.
We have just witnessed one of the most controversial Supreme Court terms in modern history, with back-to-back rulings that made for a dramatic week. Today, we're going to talk about some of those cases and what they mean to you. First, let's start with Roe v. Wade. Olen, can you explain why the court was able to overturn this ruling?
Yeah, so in 2018, there was a Mississippi state law banning abortions after the first 15 weeks of pregnancy, and that was challenged in the Mississippi courts under Dobbs v. Jackson Women's Health. And based on the timeline, right? So a lawsuit usually takes, especially one of this magnitude, several years, and then with appeals and other post judgment proceedings, it could take even longer. So based on the timing of this constitutional challenge of the Mississippi law and the shifting of the Supreme Court based on some of the appointments made under the last administration, specifically Amy Coney Barrett in 2020, the court was positioned in a way that the question of abortion and the constitutionality of that was ripe for a challenge based on the type of voting that those justices usually partake in. And so, again, the Supreme Court has jurisdiction over its own docket. It has the freedom to choose what cases it wants to take and what cases it wants to hear. And so now is deemed the appropriate time to hear this issue.
It's interesting because a lot of these issues, cases touching the issues exist all the time. And it's interesting that at least to me, that this case probably was in the hopper for a number of years. Like you said, it was a 2018 law. Just looking back at the procedural history, it looks like the court at the district level granted summary judgment to enjoin the enforcement of the law in 2018. And so if you think about that, it went through the appeal process, and the appeal process took 3 years thereabouts to get to the Supreme Court. Yeah. Now, whether that's a legitimate 3 years or whether there was some tactful appeals, I think that's interesting positioning by the proponents of Mississippi's law.
And another interesting thing about Dobbs is that there were over 140 amicus briefs filed, which, for those who don't know, an amicus brief is basically an argument, a legal argument that is filed by a non-party to the lawsuit or to the case. So over 140 different law firms, attorneys,
nonprofit organizations,
groups filed what, basically advising the court, here's some law and here's some precedent, here's some facts that you should consider when ruling on this case. And I think it's second to Obergefell as the most amicus briefs filed in support or in opposition of a position before the Supreme Court in our history.
Wow. So since this ruling, we've heard a lot of the term packing the court. Can you explain to us what that is, why we haven't seen it done in a long time, and how likely it is for us to see that again?
Yeah, so the sitting president, has the ability to nominate justices to the Supreme Court to become associate justices. And not every president gets the ability to do that, certainly not in the magnitude that the last administration had. Obviously, there's deaths and there's retirements. Those are the only two ways, I believe. I don't know that a Supreme Court justice has ever been impeached or removed.
There's resignation. Do you say retirement?
Yeah, retirement. Yeah. So there's a third way, but I don't think that's ever happened. I could be wrong on that. And so, yeah, so when a justice dies, they have a lifelong term or retires, then the sitting president has the opportunity to nominate, and then they have to go through confirmation hearings and the vote. So obviously, people will remember Merrick Garland with President Obama and how that was a nomination that was made but not fulfilled or confirmed. And then, yeah, so just the timing happened to be with RBG's death and the other vacancies that happened during the last administration. That there were three new appointees, obviously leaning the same way as they tend to go. The current administration typically either nominates justices that are more of their political affiliation, or to be a little bit more pleasing, especially if it's in an election term. They'll maybe go more independent, more moderate, just to not heavily play favorites. But yeah, that's what we saw happen in the last administration, and that's why we're looking at a typically a 6-3 split on the vote now at the Supreme Court level.
One Supreme Court justice has been impeached.
I
Good
thought
old,
I thought there was one
good
like
old Google,
Thanks, Dan.
Samuel Chase, and then it looks like there was a second. Abe Fortas resigned uh,
before we reached,
under
or
threat of
yeah,
impeachment. Yeah,
and this is what 1800s, early 1900s.
it looks like Chase was 1805,
Oh, okay.
1804, and Fortas was more recent than that.
Hmm.
I think that was like during the Lyndon Johnson years.
Oh wow.
Yeah.
Okay, so I hear as kind of like a response to that hacking the court, well, why don't we then add more Supreme Court justices to balance out that split?
We can. There's nothing in the Constitution outlining how many justices there can or cannot be. Originally, there were six, and good old Google's telling me that during the Civil War, there were as many as 10.
All right.
Um, and 1869 was the first and last time that there were nine. So it's been nine since 1869. But yeah, there's technically nothing preventing more.
So, how would that process even begin? How would a current president go about that?
Make a nomination. I think the process doesn't change. Make a nomination, go through the confirmation hearings, and get the vote. Now, I think there would be people from both sides of the aisle, if you will, who would vote no on any new justice if that number would be make them 10. So
So, it'd have to be an odd number to make sure there's no tie.
no, no, not that. I mean, I think if there was an attempt to expand to make it 10 or 11 or 15, I think it wouldn't pass strictly because there wouldn't be a yes vote, regardless of qualifications, regardless of, you know, if there was a traditional quote vacancy, if there were only eight and a ninth was needed, that person could be 100% vote yes. And I don't think they would pass today because I don't think there's a uniform opinion um, in Congress about expanding right now.
Not to mention the whole idea of packing the court. At least, I mean, at least the argument is that often it's packed with, like you said, justices that have the same political affiliation as the president or the administration at that time. If Biden was to nominate three more, six more justices, then he would do it with justices that have a similar political affiliation to him. And therefore, why would a Senate that is at best 50-50?
Yeah. Well, and the flip side of that too is then if and when the administration ever changes, now we have 15 justices, and the next Republican president nominates six more,
Right.
and we have 21. And yeah, so I think there's definitely an argument to be made as to limiting or capping it. I don't know that nine is the perfect number, but it seems to have been something we were fine for the last, what, 140 years, 150 years now. So,
I think for those of our listeners that were unhappy with the number of nominations that the Trump administration got, I mean, that was more happenstance than anything.
Right.
yeah.
Unfortunate for those people that were upset with it,
Mhm.
but I don't know that that happenstance is a reason to change what has otherwise been a functioning system for a couple hundred years.
Right.
Yeah.
So, how many more years do you think before the political lean on the Supreme Court balances out? I mean, it's hard to guess these types of things, but
Several decades. Yeah.
Yeah. I mean,
Yeah.
so just sit tight.
the two newest, or, well, not the two newest. Um,
The two youngest.
I was going to say the two newest, but Ketanji Brown is technically the newest. So
Sure.
the two newest of the Trump appointees are in their 40s, I believe, both,
40s or
or
50s. I
early
think
50s.
I think Justice Coney Barrett is 50s.
52. Yeah.
Yeah.
So just knowing average lifespan, and then knowing that these people are probably have a heightened lifespan based on the security they have, and the lifestyle they have, and the yeah, I mean, we're looking at 30 years for each of them alone.
All right. Well, on to the next one. We're going to include a clip from our Instagram page. Darius is often updating on immigration news. And when the Supreme Court ruled in favor of the Biden administration against Texas for the Remain in Mexico policy, he was all over it. So check it out.
This decision is a win on its own, but on top of that, the language from the ruling should be helpful for the Biden administration's future immigration efforts, which we will talk about in part two. In the Biden administration's first year alone, multiple lower court rulings issued injunctions which effectively stymied multiple attempts to advance immigration policy. So this is good news for dreamers, this is good news for DACA, this is good news for border policy, this is good news for reform.
Remember that there's a lot of other roadblocks, so it doesn't just open a gate and allow people in. They still have to wait for their hearing date. There's going to be processing. On top of that, recall Title 42 is still in place, which is a health provision that's been used to turn away people at the border seeking asylum.
The program, officially titled the Migrant Protection Protocols, was first put in place in 2019 by President Trump. Under the policy, migrants seeking entry into the U.S. had to stay in Mexico while they waited for their court hearings, rather than wait in the United States. About 70,000 people were enrolled in the program, leading to refugee camps on the Mexico side of the border.
What it led to was a lot of people who may not even be residents of a certain country having to stay in Mexico while awaiting their trial, which could take weeks, months, and in that time, subjected to a lot of potential for harm or danger, human trafficking, extortion, violence.
In the Oklahoma versus Castro Huerta case, after ruling that much of Oklahoma falls within Indian reservations, the Supreme Court ruled that state authorities may prosecute non-Indians who commit crimes against Indians on those reservations. At first glance, I think a lot of people thought this could be a good thing because we've heard so much troubling statistics about violent crimes against Indigenous people and the difficulty in prosecuting cases of this. But this could actually be a little more complicated, right? So, what's your guys' first thought when you heard about this case?
Well, it was somewhat surprising because we have similar, and I'm not too well versed in them, but we have similar laws here. Most states, I think, with a substantive Native American population with tribal lands, specifically dedicated tribal lands, have different jurisdiction for those tribes. And so when I first heard just the headline, um, it seemed like it was the state taking away power and jurisdiction from likely the people who would be most interested in prosecuting a case and reaching a determination on it. So
Can you explain that a little bit more? Why is that?
I guess without delving too deep into the long and tragic history of Native Americans in the United States, I think the inherent interest of the tribe and the native people to have some sort of say and governance over events that happen on their lands without having to kind of be at the beck and call or the the timeline of the federal government or the state government, um, was one remaining shred of sovereignty that they had. And I think taking that away from them is, again, for depending on what the reasons are, a step in the wrong direction.
At the same time, though, I mean, both the state and the federal government certainly have an interest in enforcing federal and state law against non-Indian residents, so residents of the state of Oklahoma. So, from the state's view, if a resident of the state of Oklahoma, like the gentleman in this case, um, goes on to tribal land and commits a crime, the fact that it happens on tribal land, again, in the state's view, shouldn't exempt him from being prosecuted under state law. Point taken that maybe the Native Americans have a greater interest in prosecuting that crime as well. Um, it's interesting though. I think I haven't read the case fully, but I mean, there's concurrent jurisdiction between federal and state law in many instances. Um, it's right. No, that's my point. What's to stop though state and tribal law from having concurrent jurisdiction?
True. I mean, I think there's two arguments to be made. I think one argument in favor of allowing concurrent jurisdiction is that you can expedite the prosecution of cases. A tribal court is obviously going to be limited in its capacity to churn out cases and take cases to trial, specifically if it's a criminal defense case where the tribe needs to provide public defender, for example, for the defendant. So I think here the state of Oklahoma can probably hear the case start to finish a lot faster than the tribe can. On the other side, I think there's potentially, among many things, an inherent risk that the state of Oklahoma may not have as vested of an interest in doing justice. There might not be the same, um, prosecution to the same level. Now that can go both ways. There could be overzealous prosecution specifically because it is a tribal case, but there could be, a lot more potentially favorable plea deals given by the state to, non-tribal citizens. So I think it's too nebulous for me to say this is good or bad on those reasons. But I think the fact that it is taking away jurisdiction from the tribe is probably not the best.
Well, and to be fair, and in looking at the summary of the case, there are exceptions to the state's overriding jurisdiction. So it looks like the um, the standard exceptions for federal preemption will apply here in favor of the tribe as they would for the federal government. And in addition to that, it looks like the justices also created or allowed for some sort of exception if the exercise of jurisdiction by the state would infringe upon self-government by the tribe. So it seems like there will be some limits. It's just those limits were not tapped here. Um, and then another point that I think is interesting is Justice Gorsuch uh, dissented in this case and said that the decision reneges on centuries of promises that tribes would forever remain free from interference by the state, right? And so to your point, um, I think at the even if we take like a minimalistic view or a narrow view on this case, it infringes on that right.
It whittles away at their sovereignty.
Exactly.
Thank you guys for that. So next, the Supreme Court took a wrecking ball to the EPA, the Environmental Protection Agency, and then shortly after gutted the Clean Air Act. First, they said that the EPA didn't have the authority to enforce the Clean Air Act and all of its goals, and then they said, "What Clean Air Act?" So, how did they reason this?
So the EPA needs congressional authority as a federal agency to take any action, right? So that's the baseline. And what the Supreme Court said here is that there are certain things, this being one of them, that the EPA needs to be able to point to clear congressional authorization. So, like express words from Congress to regulate in the way that it wants to regulate. And what the Supreme Court concluded was that the Clean Air Act doesn't expressly authorize the EPA to regulate greenhouse gas emissions in virtually any industry. So the EPA had to admit that electricity transmission, distribution, and storage are not traditionally within the EPA's expertise. But the EPA said, that's okay. Congress implicitly gave us the authority to regulate these issues. And this case, in this case, the Supreme Court said, no, that's not good enough. You need clear authorization from Congress to regulate in the way that you've been regulating. So I wouldn't call it a wrecking ball to the EPA or a gut to the Clean Air Act. I'd call it a temporary setback, because this just tees up, if you think about it, it just tees up Congress for assuming that it can act. It tees up the actual clear authority that the EPA will need. So the Supreme Court says, you didn't have what you needed, but here's how you get it. And now Congress has to act if that's what Congress wants.
I like that. That's
Who was
helpful.
concerned by EPA's unbridled power?
The car manufacturing industry, I feel like, is like number one.
And what did they thought that they were being oppressed by the restrictions to a point that what made them
That the cost of manufacturing was going to go up so much to try and meet these regulations that they could no longer compete with manufacturers across the world.
driving down local product for imports.
Right. You know, it's just interesting though, because it's like they say you get what you pay for, and the whole thing is the cost of manufacturing. So it's like, yeah, you can take the cheap route, but our air is only gonna last for so long before it's gonna turn into a luxury good. So
Was it regulating the actual emissions of the product, or was it regulating the manufacture of the product, or both?
Yeah, so the background for the case is that the Trump administration repealed the Clean Power Plan, which imposed emission standards, specifically for, it looks like, carbon dioxide emissions from power plants. So Trump repealed that, issued in place the Affordable Clean Energy Rule, which eliminated or deferred those same guidelines, pushed them out. The DC Circuit vacated that Trump deferral rule as arbitrary and capricious. And so that's the procedural background for this case.
Interesting.
Is reimposing those guidelines.
Reimposing an arbitrary and capricious decision.
Well, it's the appeal of the arbitrary and capricious holding.
Right.
Yeah.
one thing that I'm always really proud to be an Arizonan for is that, here we don't have to be forced to adapt. And in Pinal County, we have Lucid and Nikola Energy, which are two companies in electric vehicles. So,
EV's big. I've had a hybrid since 2014.
so next up, the Second Amendment. The Supreme Court ruled against New York's restrictive gun laws, saying they were unconstitutional. The Supreme Court struck down a New York state law requiring applicants for a license to carry a gun outside of their homes to have a proper cause to do so. Now, Olin, you feel like that is a poorly written law. Tell us why.
What I'm seeing is that there was a threshold that you had to meet to get. So the only way in New York you can have a handgun um, is if it's outside the home, is if it's a concealed under a concealed carry permit, or could before this change. The only way to get a concealed carry permit was to show that you had a heightened need for it, and that is what is unclear to me is how one would do that. There's not a checkbox that you could say. So, for example, I don't know if I walked to work and I worked in a high violence area, if that was heightened need or not, or if I worked hours where I was taking the subway at 1 a.m., if that was enough. I'm guessing no, but I don't know. So I think part of the issue was it was too nebulous and ambiguous, and there needed to be some sort of consistency. Um, that being said, New York doesn't restrict, Dan, what we were talking about earlier. Um, you don't need a license to own or possess a rifle or a shotgun. Just this is just for handguns. So that's how the law doesn't violate the Second Amendment. Is it doesn't? Well, some would argue it does because any and all guns, free range for everyone. But here it's just for handguns, and I'm assuming that's because handguns were very common in the rampant crime in New York that they wanted to clamp down on, which is why they one said you can't have a handgun without this permit, and here's the only way you can get the permit.
It's a over 100-year-old law.
The
Looks
handgun.
like. Yeah.
So I guess I'm
It
wrong.
wasn't because of that.
Well, they could have had a lot of violence 100 years
But
ago.
I mean, nonetheless, that's a reaction that obviously a lot of people are having. They're worried if their neighborhood was already really dicey, if this is just going to make it easier for bad guys to get bad weapons. Um,
Nothing's stopping you from carrying a shotgun.
that's not legal advice.
Well, I'm not licensed in New York to give legal advice, but you don't need a license in New York to have a shotgun.
But on the other side, gun rights activists say that this is a success because the restrictive laws for concealed carry and we're almost banning guns kind of altogether.
Yeah, I think two-way proponents take this as a big victory. I think they see it as a stepping stone towards undoing the 100-year-old law that prohibits handgun um, carry outside the home. So yeah, I think they are very emboldened by this ruling.
It's an interesting time, of course, to kind of pick this hill with all of the school shootings.
The bill that did this that they had to undo, it was in response to the 2020 Buffalo shooting and the Robb Elementary School shooting. So um, it wasn't some knee-jerk reaction. Well, some would argue it was, but it wasn't a it wasn't for cause. It was they saw a problem and they decided that this was one way to try to combat it, and the Supreme Court disagreed, saying that the Second Amendment rights are more important.
I don't expect New York lawmakers to stop, though. New York's been one of the few states that has been able to pass some robust gun control laws. And it looks like the next thing down the pipeline will be marking certain places as sensitive places barring guns outright. So schools, hospitals, and potentially the subway um, in New York. So we'll see.
Yeah, it'll definitely be very interesting to watch any changes in crime data following this. Um, well, listeners, I know we gave you guys a lot of information. Thank you so much for tuning in, and we will make sure to keep you updated on all things you need to know.